Delivery of judgment, item number 1.
For reasons mentioned in the judgment, this revision petition is dismissed with cost.
Deeply obliged, Your Lordship.
Mention legally.
Great, this is your Lordship. Lordship, I would like to mention two items for orders. One is, Lordship, the insurance company wants to place it before the local adult. They want to settle this case
When do you?
tomorrow. Lord. It is for orders only. 8th of delay, Lordship, if it is on 8th, then the local adalat is on Saturday. It won't be. That's why we need it
Okay, tomorrow. Allowed.
earlier.
May I please, Lordship? Lordship, I'll pay for a listing of new matter, tomorrow, my lord. There is an urgency, my lord.
When have you filed?
Friday, my lord. Lordship, even this lower court case is fixed tomorrow, my lord. Therefore, there is an urgency, my lord.
Okay, tomorrow.
Lordship, I leave this.
It's also listing for a matter. This is testamentary, it is listing for execution. It was last listed on 27/5/25, and it was fixed on 10/6, but it was not listed. And thereafter it will be listed.
15th.
Thursday, not.
15th of May.
May it please your lordship. My lord, I beg to mention item number 5 of the daily cause list of court number 9. My lord,
Court number 9 matters are deferred.
deferred, but my lord, there's a provision, my lord, if there is urgency, my lord, there's in the notice itself, my lord, it says it can be mentioned over here. My lord, my case involves urgency. In
What urgency?
my lord, here, my lord, order 9, rule 13 petition was allowed. And against that, my lord, we have come in revision before this honorable court, but the order says that the suit will now be restored to file and will now proceed with the next date fixed for filing of written statement by the defendants who have got the order setting aside the ex parte decree. I am the plaintiff in the suit. And my lord, in view of that, my lord, I have filed.
What do you want?
Can it be taken up in this week except for 7th any date, my lord? This is a motion matter, my lord.
On 8th,
8th Friday.
Friday.
Mention memo. Mal.
For listing by MSC appeal lodge for orders on Friday lodge.
8th. 8th. Eighth. 8th.
May please your lordship. I beg to mention in this case, may case be made fixed on 12 or 14 years.
In this case, at what stage?
Yes, sir.
In what stage?
It is orders. Orders. Can it be on
15th.
16th year?
16th, okay.
Obliged.
15th.
Obliged.
Yes.
Lordship, I second listing on Friday, Lordship. In fact, matter was given, matter was permitted for listing today, but.
Okay. 8th.
Yeah, please, madam. I'm paying for listing of an RSA for motion. We listed on 7th.
Okay.
7th. Obliged.
May it please your lordship. Lordship, I pray for listing an interlocutory application, lordship. Application under 151 of CPC, lordship.
When have you filed?
Today, lordship.
It will be automatically listed within 2 days.
Wednesday, lord.
Okay.
May please your lordship. Lordship, I beg to mention for listing of 3 items. One is one CRP, 2 are CRPs and one is one I for promotion delay
What is the stage?
in orders. Can it be on Monday on 11th?
Okay.
May I please, lordship. For listing, my lord, one hearing matter, my lord, on last listed on 2022, my lord.
It will come in orders column first.
But already my matter has been fixed for hearing, my lord. For final hearing, my lord.
What was the order passed on last occasion?
On last occasion, my lord,
You don't know.
I don't know, my lord.
Therefore, it will come in
Yes, yes.
orders column.
But my lord, matter has been fixed for final hearing.
Eight order columns.
My lord, on 8th, my lord. Obligation, another similar matter, my lord. Two matters, my lord.
In orders
Sim-
column. On
My
eight.
lord. Obligation, my lord.
Which column? 11th.
May it please your lordship, I beg to mention listing of two MFA at the order column for next week.
11th.
11. Much obliged.
Which hearing column? Hearing column 16 July.
May it please your lordship. Lordship, I beg to mention item number 2 listed in code number 9, lordship. Lordship, this CRP is one landlord tenant case, lordship. I am the tenant, and by judgment and decree, I have been declared as defaulter, and the execution proceeding is pending in the trial court. So one short date may be given, lordship.
No, registry will give you date. Matters are deferred by notice says that matters are deferred. If you want a fixed date, approach registry. Registry will give you date.
Obliged.
daily list motion দিয়ে item 2
Your lordship, this issue, this matter was already decided. Bail was rejected by your lordship. Now they have filed a fresh bail application on the same ground. That section 47 and 48 notice was not served. Now, let me just complete. Now, what has actually happened here, your lordship, they have not even annexed that early order in this bail application. So they have not come with clean hands. Now, on last
Whether
occasion,
they have stated that their petition was rejected earlier.
no, your lordship,
That
here,
statement is there or not?
but they have not annexed their early order. That is very necessary.
That order you have to annex.
And last occasion, they took time to file an additional affidavit bringing on record that order. That has not come on record, your lordship. So,
You bring the rejection order on record. Let
Yes.
them bring. Heard Miss,
the TCR will also be called for, your lordship.
what is your name? Heard Miss J. Singh for learned counsel for the petitioner. Also heard Mr. D. Bora,
Deborah for
learned
DRI.
counsel representing DRI. Learned counsel for the petitioner prays for some more time to file an additional affidavit for bringing on record the order of rejection of bail, which was filed by the petitioner on earlier occasion. The prayer is allowed. Let this matter be listed on 1st of June. Let the record scan copy of the trial court records along with the scan copy of the connected case diary be called for from the trial court. The registry shall take steps for requisitioning the scan copy list accordingly.
item 3
It's a charge sheeted case, man. Please call for the records.
Charge sheeted case, why anticipatory bail?
My lord, earlier, my lord, the case was withdrawn, my lord, as because the charge sheet was filed. He has been shown as an absconder. Case 42, my lord, the court below.
Notice also need to be issued, Lordship. POCSO case.
It is a POCSO matter.
Notice need to be issued.
Then your bail application is not maintainable.
My lord, in fact, my lord, there's a compromise came before this court, my lord. It was a cross case also. That's why.
You plead your case.
Picked up your lordship for the record.
Now we'll decide whether to, after, let the rejection order come on record.
I'm of that.
basically item 21
In this case, PCR was called for, but it was not received, Lordship. PCR call for, but no petitions.
None appeared for the petitioner on call. Mr. K. Das, learned additional public prosecutor, is present. On perusal of the office note dated 24/2026, it appears that the scanned copy of the trial court records, which was called for, has not yet been received. The registry to issue reminder for the same. Let this matter be listed again on
Second P.
22nd May.
Item 22.
The petitioner is a 59 years old subject. Is suspended from last 7 months and going to retire after 6 months also. My ground was 35 rupees month. Missing till now 7 months are passed.
Lordship, regarding that, this earlier rejected 2 times, Lordship, this person. And moreover, regarding after the rejection of the bail order, Lordship, there is a note in the IO note, Lordship. It has stated that they tried to give 35-3, but no one is present at the house, Lordship, so they cannot serve it. It is there, but they still trying. Otherwise, Lordship, it has been rejected 2 times and it is implicated. Implication is there, Lordship. 183 statement is there of the victim and the mother to whom, Lordship, this she has told, Lordship, the whole incident, it is also there. It matches with the FIR, Lordship.
No, where is the earlier rejection order?
Lordship. And moreover, Lordship, in second bail rejection, Lordship, this has already been taken care of, Lordship. In paragraph 18, page 49. And 21 also, Lordship. It has been taken care of, and after seeing all the things, Lordship, consideration of all these things, it has been rejected, Lordship.
My lord, I was appointed as an.
Yes, Mr. Day.
I was on the last occasion, my lord
Yeah,
had appointed me as an amicus in this case, my lord. Apart from what my learned friend has submitted from the prosecution side, my lord, few things falls important, my lord. There is a prima facie strength on the allegation in the FIR, my lord, which has been filed against the accused in this case. There is no justification as to why such allegation has been laid. There is no justification in the bail petition. There is no prima facie attempt also been made by the accused petitioner to justify the why this particular incident had happened. Secondly, my lord, there is no delay in lodging of the FIR. The FIR was lodged in very next day.
Item number 4.
We'll take it up after some time.
Item 5.
In this case, I am referring to the appellant, my lord. It is an IA where we have filed our affidavit on 16th of March. This one in the record, my
Affidavit?
affidavit in connection with the modification which is filed by my friend. It was filed long back 16th of March 2026. There's an IA, your lordship, 3858.
Some interim relief was granted.
My lord, in fact, interim relief was granted, then they appeared and filed a notification petition where we have put.
What has happened in the trial court?
Trial court, my learned friend appeared. He yet to file their WS in the suit.
In IA?
In
this case?
nothing. Only.
WS has been filed.
My lord,
WS has been filed, yeah. We can
No,
object
but
and we-
here you have come against the injunction application.
The injunction, no, they filed a FAO.
This FAO has been filed against the order passed in the injunction application.
So we from this honorable court, this honorable court protected us. Date were fixed on the date
After 12 or at 2 o'clock, somebody files an objection or refuse cases, we will be able to collect it on the next day. But my instruction is as on this date, no objection is filed in the injunction. So far, he is saying WS was also not filed in the date file. If he has filed in subsequent date, then I am not aware of it. Now, here in the modification petition, he sought some modification in connection with the interim order, my lord, and we have filed objection that modification.
No, instead of fighting this matter here, you could
Kindly,
agitate before the trial court.
That's the right. Let them appear.
You file your written objection before the trial court. Let the trial court decide.
Interim to continue, bro. Until then, interim will
No,
continue,
no,
let them
no,
file their
no,
objection and hearing.
my lord, just have a look, of.
Who is in possession
I'll
of
open
that?
the floor.
My lord, the Eastern Enterprise, there is the firm, the respondent 1 and 2 are the partners. Earlier, the partnership deed was, partnership deed was constituted between appellant 1 and 2 and respondent 1. And later on, my lord, due to their old age, that is the appellant 1 and 2, they.
No, no. What is the impact of the order dated 26/9/2025?
26/9 to.
My lord,
9/9. Just have a look,
Just, we received the copy of the agreement on 12th of September 2025. Till then, I was running the show. And then we filed suit. Notice was issued on 22nd of September 2025. Till that day, we were running the show. And on 26th of September, when this honorable court protected me, in fact, I was on the show, my lord. So, my lord, nothing will happen. My lord, this is a case between father and son, my lord. I'm not going into the merit of the case. Your lordship will decide.
Lord-
Let the trial court decide, my lord.
Lordship, they sealed the order 22nd/9/2025 also, passed by the trial court. They prayed for ex parte ad interim injunction and that pair was rejected. And the notice was issued for being heard by the other side.
But for last 8 to 9 months, this stays in operation. Stay granted by this court is in operation for last 8 months.
Yes.
Now, who is managing the affairs of this Messrs. Eastern Enterprise?
Eastern Enterprise, respondent 1 and 2 are the only partners of Eastern Enterprise. So they,
No,
we are in not in a
then
position
what
to
is the
run
impact?
business, ma'am.
What is the impact of this order dated 26/9/2025?
One is running the farm right now. Pursuant to order of this honorable court.
We are
The
not in a
agreement
position
is
to
in
run the
place.
business because, in spite of that, we are the partners, respondent 1 and 2 are the partners, ma'am. And super kindly appreciate the order, my lord, so far 22nd/9/2025, my lord. What was narrated in the orders, paragraph 3, my lord? May I read, my lord?
That they approached lately.
Yes, my lord. The reconstituted deed was challenged in the trial court, my lord. And that deed was registered on 2022, my lord. And they came to the trial court after 3 years, my lord. That's why rightly this
Okay,
order
okay.
was passed.
You want to file a rejoinder against their.
Your lordship's suggestion was quite genuine, my lord.
But he has to be agreeable.
Till 1 month. 1 month heaven will not fall, my lord. Ma'am, I am his father, my lord.
I'm the respondent 1 and 2 are the partners, only the partners of the Eastern Enterprise.
And I am not going
Oh.
into the case.
No,
Without going into merit of the case, my lord, your lordship.
that they are assailing the order ex parte ad interim injunction, my lord. Whether that was rightly passed or not, the rejection was rightly passed or not, that is the question, my lord.
Yes.
That is the question. They came after 3 years, my lord. They could have waited for 1 month, my lord. That's why notice was issued, my lord. So it was rightly passed, my lord. The FAO is only for this order, assailing that order, my lord. The merit will be decided in the trial court. What they allege that the fraud was done, that the fraud will be decided in the trial.
Okay, you are, both of you are ready for hearing, final hearing on this appeal today.
My lord, but my objection petition has come here for you.
That is in the,
I ate the notification.
if we decide the final, if we finally decide the appeal, the question of dealing the IA separately may not arise.
Subject to my convenience of my friend.
I think
Are you ready today?
ready today.
In fact, I'm not.
I'm ready today, my lord, because we are in.
Then we will give a short date.
Any date, my lord.
Let the matter come on Friday, my. Because we are in halt, we are not in a position to run the business, my.
Yes. Heard Mr. H. Das, learned counsel appearing for the appellants. Also heard Mr.
And Taluk.
M. Talukdar,
And Taluk.
N.
And Taluk.
N.
Normal Taluk.
Talukdar, learned counsel appearing for the respondents. It is submitted by learned counsel for both sides that this appeal may be taken up for hearing for final disposal. However, learned counsel for the appellant seeks a little accommodation. When can we fix?
Friday. My lord.
8th. Let this matter be listed again on 8th of May in admission hearing column. Endeavor should be made, shall be made on that day to finally dispose of this appeal. List accordingly.
Well, the objection that please will be directed to patient record.
Learned counsel for the appellant has submitted that he has filed an written objection in the interlocutory application filed by the present respondent in the connected present respondent. The registry is directed to place the written objection filed by the present appellant on record on the next date. The interim order shall continue till next day.
That copy may be served, my.
Well, without survey, hoping we cannot find it. There is an option.
Actually, I'm newly engaged, man. That's why.
You serve a copy.
Item 6.
It's a statutory appeal lordship against an judgment and order taken 12/1/2026. Passed by the additional Texas Kamrup at Mindown in reference case number 1 of 2024 in LA case number 7 of 2022. By which the actually reference application has been rejected for enhancement of the market value of land. The ground of appeal are lordship, the appellant has exhibited pre-sale in which the market value of land has been shown as approximately 85 lakhs.
The adjacent plots.
That is the sale deed of a land of the same village in which the land has been acquired. That has been executed.
Will issue notice, Mr. Nath. Heard. Mr. A. Deka, learned counsel for the appellant. Also heard Mr. D. Nath, learned senior government counsel, appearing for respondent number. All the respondents. All the respondents. This appeal under section 74 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 read with section 96 of the Code of Civil Procedure has been filed by the petitioners, by the appellants, impugning the judgment and decree dated 12/1/2026 by the Court of Learned Additional District Judge Amingaon, Kamrup, in ELEC reference case number 1/2024 in why two LA cases? In LA case number 7 of 22, whereby the prayer for enhancement of the compensation awarded to the present appellant was rejected. Issue notice to the respondent. Since Mr. D. Nath has already appeared for all the respondents, no formal notice need to be issued. Stop. Let the records of LA reference case number 1/2024 along with connected records be called for from the Court of Learned Additional District Judge Kamrup. Registry to take steps for requisitioning the records. Let this matter be listed on 1st of June.
You will give me the copies. No?
Yes.
Copy club.
I am not, you furnish the copy.
I'll find. Item 7. May I please, Lordship? The similar case, Lordship, only its reference case is different. Same land acquisition.
Heard Mr. S.D. Purkasta, same order, reference case difference.
Here, Malab, the amount has been enhanced. He wants more enhancement.
No. Rejected.
No, then the copy is different.
Rejected. Page 80.
Hmm?
80, page 80. Rejected.
Same order.
Reference case number 2 of 2020.
Okay. Change the reference case number. 1st of June. First.
Item 8.
This is an appeal filed against the dismissal of my ex parte application, my lord, whereby I had filed an application under Order 9 Rule 30 for setting aside the ex parte judgment and decree. What has happened in this case is that my lord, the present respondent, he filed a suit for specific performance of contract. The plaintiff, my lord, will find at page number 80.
Okay.
Specific, hereafter, my lord, the suit proceeded ex parte, and the suit was decreed. Judgment, my lord, will find 63. The relevant portion, if my lord, comes to page number 65.
Yes.
My lord, order, para 10, in the result, the suit is decreed ex parte with cause which are following relates to the plaintiff. The plaintiff number 2 is entitled to decree for specific performance of contract of sale, and the defendant is liable to deliver back in possession of the scheduled flat to the plaintiff number 2 within next 30 days. So, my lord, the suit was decreed ex parte in their favor, and till that time, my lord, I had absolutely no knowledge.
Where is the impugn order?
Impugn order, my lord, will find at page number 147. Annexure. Annexure 9 series. Order dated 20/1/2026.
Why your prayer was rejected?
Well, interestingly, my lord, I had filed an application for sending my signatures to the forensic laboratory, my lord. That was allowed. If my lord kindly comes to page number 104, my lord, before the impugn order, this is quite relevant. Page 104. order dated 8/4/2019. Parties are represented in the contents of petition number 403/17 by the learned counsel of both the sides. Peru's case records of the episode 410 of 14 along with documents appended here. On perusal and after hearing what transpires is that according to the petitioner, the process server of his court, without serving summons upon him and had given a report of service, he also disputes his signature over the Hazira dated 18/3/2015 available in the case record of package suit number 410 of 2014. Now, as the petitioner had taken non-service of summons as the ground for non-appearance in the trial, so in the interest of justice to decide this case on merit, in my considered opinion, it is necessary to send the disputed signature of the petitioner appearing on the overleaf of the summons dated 16/2015 and the disputed his alleged signature appearing on the Hazira dated 18/3/2015 along with his admitted signature appearing on the Wakalatnama of the instant case to FSL for examination. The petitioner shall take steps within 7 days of report.
What happened thereafter?
Hereafter, my lord, I have been taken steps and sometimes the report has not arrived. Somehow the report has not come and the court has been on timely basis, my lord, has been directing me to take steps. Sometimes I've been taking steps, my lord, but somehow the report.
Taking steps for sending your handwriting.
Handwriting that I have already sent back way back in the year 2021.
Then what happened?
Nothing has been done. No report has been received till date. Now, my lord, by the impugned order that my lord will see at page number 147, the whole burden has been shifted upon me, my lord, that I have failed to produce the record of the forensic laboratories, my lord. And as such, my condemnation application along with the order and rule 13 application has been dismissed. My lord, may I read, my lord?
Yes.
Both parties are represented. Today is fixed for FSL report, necessary order. Learned counsel for the degree holder has submitted that the FSL report has not yet been received today. On the other hand, the learned counsel for the judgment data has submitted that it is the duty of the forensic science laboratory to send the report for both sides. Upon perusal of the case record, it appears that as per order dated 12/12/2025, learned counsel for the judgment data has assured this court that the report will be submitted on the next day, that is today. However, once again, new submission has been made before the court. On perusal of the entire case record, it reveals that the judgment data has filed two applications, petition numbers 4031 of 17 and 4032 of 17. These are my condemnation application and order 9 rule 13 application. And the entire issue in this regard to the matter relating to the.
No. 4031 is
40 order 9 rule 13, my lord, and 4032 is my condemnation application.
there was delay in filing.
Delay in filing the order 9 rule 13.
How much delay?
My lord, from the date of receipt of the certified copies, my lord, it was 30 days. Around 30-35 days.
Okay.
However, despite directions being issued on 12/12/2025 by this court, it appears that no such report from the forensic science laboratory has been received. It also appears that as it is an execution matter, the decree holder cannot be deprived of the fruits of the decree. The execution in connection with the case was filed in the year 2016, but the state execution proceeding could not be proceeded till today in view of the aforesaid mistake. Hence, it is quite clear that the judgment that the petitioner has been granted more than sufficient time and the petitioner is unable to submit the report of the adversary.
A report had to be submitted to the court by the forensic laboratory.
I have got no, only thing that I can do is I can take steps at the best.
Yes.
That is my right and requirement. But the court has shifted the burden upon me, which has been languishing for more than 6.5 years, and the decree holder is deprived of the fruits of the. Hence, the light of the application, this court is of the opinion, the said petition number so and so and are hereby rejected. Interestingly, my lord, my misapplication, that is my lord 4032 of 17, says section condemnation application, that was not even registered. And straight away, my lord, my condemnation petition and my ordinary rule 13 application, just because the report of the FSL has not been received, has been dismissed.
Yes.
Very capital.
You have anything to say?
As has been delivered into 16. Now.
No, but there appears to be some
Yeah,
error in
actually
the
report, yeah.
impugn.
That is the other.
My response submission, instead of keeping the matter, my lord, since he is also suffering, my lord, let the matter go back, my lord. Otherwise, there is no point keeping the matter.
Yes.
Look at,
We are remanding the matter back,
to be,
giving a fixed time.
That would suffice.
The trial court may take steps for calling the FSL report.
And the trial can also show cause also, my lord, under order 16 rule 10, my lord.
Yes.
Impose fine also upon.
The order?
Rule 16 rule 10, my lord. it can impose fine also upon any party, my lord, who has been directed to produce a document or evidence, which has not been done.
What is Order 16 Rule 10? Heard Mr. A. Iqbal, learned counsel for the appellant. Also heard Mr. What is your name?
SN Borwa.
S.N. Borwa. Learned S.M. Borwa, learned counsel for the caveator. This appeal under Order 43, Rule 1 within bracket D, small d, read with Section 151 of the Code of Civil Procedure 1908 has been filed by the appellant Shri Sanjay Kumar Borwa, impugning the order dated 21/2026 passed by the Court of Learned Civil Judge Senior Division Number 3 Kamrup Metro, at Gauhati in Miss J case number 727/2017 arising out of title suit number 4110/2014, whereby the application filed by the present appellant under Order 9 Rule 13 of the Code of Civil Procedure for setting aside ex parte judgment and decree dated 22/4/2016 was dismissed. The next para. The facts relevant for consideration of the instant appeal, in brief, are that the present respondents as plaintiffs had filed a title suit for specific performance of agreement for sale dated 21/12/2012 executed by the present appellant as well as the respondents, and for permanent injunction. The said suit was filed before the Court of Learned Civil Judge Senior Division Number 3 Kamrup Metro and was registered as title suit number 4110/2014. The summons were issued to the defendant within bracket present appellate in the aforesaid suit, and when the appellant failed to appear before the trial court in spite of due service of summons, the suit proceeded ex parte and ultimately by judgment dated 22/4/2016, the suit was decreed ex parte against the present appellant. Stop. Learned counsel for the appellant has submitted that the present appellant approached the trial court by filing an application under Order 9, Rule 13 for setting aside the ex parte decree. In the said application, he took the plea that the summons summons in the aforesaid suit have never been served on the present appellant. Learned counsel for the appellant further submits that since there was a delay in approaching the court for filing the application for setting aside ex parte decree, the present petitioner had also filed an application under Section 5 of the Limitation Act for condoning the delay in filing the application under Order 9, Rule 13 of CPC. Stop. He submits that said application was registered as petition number 4032/2017. Learned counsel for the petitioner has submitted that, learned counsel for the appellant has submitted that since the plea of the petitioner, plea of the present appellant before the trial court was that he never received summons and the process server had filed a wrong report of service without serving the notice summons on him. And since somebody filed Hajira also,
It's clerk is fine.
and since one Hajira within inverted comma was also shown to have been filed in the title suit number 4110/2014 bearing the signatures of the present appellant, which he denies, comma, he prayed for. No, he filed an application before the trial court praying for sending his signatures as well as the disputed signatures appearing on the summons and as well as on the Hajira to the forensic laboratory for verification of the genuineness of the disputed signatures. Learned counsel for the petitioner, learned counsel for the appellant submits that the where is that FSL?
Page number 104.
FSL petition?
Petition is not there, order is there. 104.
Petition number? What is it?
032 of 70.
And what is your delay condonation petition?
My lord, or delay condonation is 4032 and my lord, order 9 rule 13 is 4031.
And this FSL petition,
Special petition is,
not number.
number is directly it's given on 8/4/2019.
The trial court has also not mentioned. What was the last line?
Was conducting the case, my lord, it has been informed, my lord, it was taken by the trial court itself, my lord. No application was.
What was the last line? No, no. Eta paragraph aro. No, he filed Katidio, which he denies. The trial, no, Katidio, which he denies. The trial court considered it necessary to send the disputed signature of the petitioner appearing on the overleaf of summons dated 16/2/2015, as well as disputed signatures of the, instead of petitioner, write the appellant appearing on Hajira dated 18/3/2015, along with his admitted signatures appearing in the Wakalatnama to the FSL, to the forensic laboratory for examination. And the present appellant was directed to take steps for sending his signatures to the forensic laboratory. Learned counsel for the petition appellant has submitted that in compliance to the directions given by the trial court on 8/4/2019, the appellant has taken steps and his admitted signatures as well as disputed signatures were sent to the forensic laboratory for examination in pursuant to the direction of the trial court. Stop. However, he submits that on several dates on which the Miss case number 727/2017 was listed before the trial court. The report from the forensic laboratory was not received. He submits that since the present appellant had taken steps for sending his disputed signature in compliance of the directions of the trial court, it was not within his control to get the report from the forensic laboratory, as same is to be submitted by the forensic laboratory to the court directly. Learned counsel for the appellant submits that on not receiving the report of the forensic laboratory within due time, the trial court could have taken steps under what is Order 16 Rule 10.
Procedure where the witness fails to comply with summons. Where a person to whom a summons has been issued either to attend, to give evidence, or to produce a document, fails to attend or to produce the documents in compliance with such summons, the court shall, if the certificate of the servicing officer has not been verified by affidavit, or if service of summons has been effected by a party, may, if the certificate has been so verified, examine out the serving officer.
And
The case may be as affected.
The trial court could have taken steps to show cause the forensic laboratory and to get the report therefrom. However, instead of doing so, it dismissed both the petitions filed by the present appellant, namely the prayer for condoning the delay of 30 days in preferring the application under Order 9 Rule 13 of CPC, as well as the application under Order 9 Rule 13 CPC itself. Shift. Shifting the blame of procuring the FSL report on the appellant. Stop. He further submits that the trial court has also erred in not considering the application filed by the appellant under Section 5 of the Limitation Act for condonation of delay on merits. It was not registered, no. He submits that even no miscase was registered on the basis of application filed by the petitioner under Section 5 of the Limitation Act. Only a petition number that is petition number 4032/2017 was allotted to it. On the other hand, Mr. Borua, learned counsel for the cavator, has submitted that the decree, ex parte decree, has been passed by the trial court when in the year 2016 itself, and the respondents who are the decree holder are deprived of the fruits of the decree without any fault on their part. He, however, fairly submits that the application under Section 5 of the Limitation Act filed by the present appellant ought to have been disposed of on merits by the trial court. Stop. I have considered the submissions made by learned counsel for both sides. It appears that by impugned order dated 21/2026, passed in Ms. J case number 727/2017 in connection with title suit number 410/2014, the trial court has dismissed both the applications filed by the present appellant, namely the application under Section 5 of the Limitation Act, praying for condoning the delay in filing the application under Order 9 Rule 13 of the Code of Civil Procedure, as well as the application for setting aside ex parte decree under Order 9 Rule 13. However, no reasons were stated for dismissing, no reasons on merit were discussed by the trial court for dismissing the said petitions. It also appears that the it was the trial court. No, it also appears that the accepted signatures as well as disputed signatures of the appellants on the summons as well as on Hajira were sent to the FSL report, forensic laboratory, not on any petition filed by the present appellant, but it was done suo motu by the trial court by its order dated 8/4/2019. Hence, this court is of considered opinion that it was incumbent on the trial court to procure the report of the forensic laboratory in respect of the examination of the signatures of the present appellant. The trial court could have called for, could have showcaused the authorities of forensic laboratories, or could have taken any other coercive measure to procure the report. However, merely due to non-receipt of forensic laboratory reports, it has erred in dismissing the application under Section 5 as well as under Order 9 Rule 13 filed by the present appellant without stating any reasons on merit. This court is therefore of the considered opinion that the impugn order dated 21/2026 is liable to be interfered with and accordingly set aside. The matter is remanded to the trial court. The trial court shall take all steps to get the report of forensic laboratory collected, a report of examination of the signatures of the appellant collected from forensic laboratory at the earliest, and thereafter, after giving opportunity to both sides, shall dispose of the application filed by the petitioner, application filed by the present appellant under Section 5 of the Limitation Act, as well as under Order 9, Rule 13 of the Code of Civil Procedure on merits. It shall endeavor to dispose of both the application as expeditiously as possible. I am not fixing any time limit. Preferably within 3 months from the date of this order. This appeal is accordingly disposed of. In view of the order passed in FAO, the IA is closed.
Item 9.
Attachment of the land file. In this case, lordship, the parties have been raising separate for considerable period. And there is no possibility.
तो पुतुल माइक्रोफोन तो ऑन असेल नहीं चेक करो. You are husband or wife? Heard, miss. What is your name? P. Das, Learned Counsel. Yes.
The time I'm approaching before this lordship, section 3, page 66. It's the first time when I approach.
Against the same order.
No, my lord. Thereafter, my lord, number of orders will pass in trial. Lordship will see order dated 12/1/2026, annexure 5, page 72. To honorable court's order, trial court has extended the order on 12th of January 2026. Just continue until further order. Now, my lord, the impugned order is at page 159 and annexure 18. My lord, this is expressly illegal apparent on the face of the report. My lord, why I am saying so, my lord?
What was the impugned order?
My lord, I will take your lordship so that I will.
Whether injunction was granted or not?
Yes, my lord, injunction was granted without hearing me, my lord. Temporary injunction was granted, which case was disposed of. It was their case. They have filed a counterclaim along with an injunction petition. Without hearing me, my.
But the order says that
Yes.
both sides are
My lord,
represented.
I will come one by one.
Speaks for order.
My lord will see annexure 11.
On that day,
Okay.
he was not heard.
No, he was not, because the case was filed on 18 to the case was filed, and on 6/3, it was fixed for objection and hearing. On the day they were present. And the matter was heard, and on 4/4/26, it was fixed, order was passed. I am the licensee of the wine shop. He is using my license
Okay.
without any valid license. This is the case,
I'll come there.
a wine shop.
First of all, my lord will kindly see annexure 11, page 160.
No, what is your case that you were
My lord.
not heard?
My lord, I was not heard on the day of the order passed. I filed 5 petitions seeking adjournment.
Oh,
My lord, I was not given any opportunity. My lord will see there are orders, page annexure 14, 15, 16. Even I am yet to file the the written statement in counterclaim, my lord.
no, we are considering the order passed in the miss case.
Yes, my lord. Now your lordship will kindly see page 189.
Yes. Yes.
Both sides are represented, paragraph 1. I was not present at that day, my lord, first of all. And then again, your lordship will see 198. Paragraph 4 and 5. There is a clearly written that against the application of fee plaintiff did not file written objection first. Secondly, thirdly, my lord, I have heard learned counsel for both the parties at length. My lord, when, my lord? And again, I will take your lordship to page 201.
You want to say that without hearing you,
Yes, my
court
lord.
has reflected that you have been heard.
My lord, I will take your lordship. Only 201. 201, last line, paragraph 10, prima facie case.
Yes.
The defendant number one counter claimant inducted the plaintiff as manager for smooth running of his shop. The plaintiff was terminated from his shop on 11/8/2025, which is denied by the plaintiff. Well, from where? I am yet to file my written statement in counterclaim.
Have you not filed objection in
I am
written?
yet to file written objection, firstly, my lord. Secondly, I am yet to file my counterclaim in the WS. My lord, your lordship will see the injunction order till disposal of the temporary title suit. Well, this is the temporary injunction without giving me any opportunity. I'm not the merit of the case. Well, at least one opportunity I should have. And this runs contrary to the order passed by this honorable court.
Your plea is that in miscase you have not been heard.
Mine,
We'll call for records of the miscase.
mine.
We'll admit the appeal.
What has happened? He was my manager. He is spending about a lot of money. After that, he filed a case before a trial court without the address was given was wrong address. He has given the address of Sanmari of I reside in Ujanda. He no manager. Thereafter they filed an affidavit under justice service that I refuse to accept the notice. Thereafter, this honorable court has against the order of trial court, they preferred appeal. And honorable trial court has said that status quo in respect to super party, only in respect to super party. Thereafter, after coming to know, I filed an application before a bank for freezing the account because he's suffering of the money, misusing my check. After that, on the guise of the High Court order, they file an application for my account for defreezing the account. The trial court has defreezed the account. After that appeared, I filed an application to freeze it. Again, the trial court freeze the account. Thereafter, I file a counterclaim and an injunction petition. Sorry, an injunction petition, not to pose as a authorized representative of me, because I'm the licensee of Maharaja Wine Shop, admitted by them in India plain. And now the court has restrained them not to use my license and not to pose as authorized representative. What is the wrong order? Because as per Excise Act, license cannot be transferred, nor there may be a partner in the license act.
So injunction is only with regard to use of your license.
License, yes, license, and not to pose as an authorized representative of the respondent. So,
Okay, we'll examine it.
Your lordship, in the plain para 3, page 3, para 3, page 3, para 3, he has stated. Page 3, para 3. That is stated the respondent one is a licensee of a Indian made foreign liquor.
Well, I don't dispute, my lord. He
He is a licensee. Made foreign liquor, they dated 1810. Because if they use my license, I'll be liable for income tax and all everything. Because it's my license. Because in a
Okay. Heard Mr. H. Das,
yes, I'll go for it.
learned counsel for the appellant. Also heard Mr. S. R. Gogoi, learned counsel for the caveator. This appeal under Order 43, Rule 1, within brackets small r of the Code of Civil Procedure 1908 has been filed by the appellant Shri Amol Narayan Shrestha, impugning the order dated 4/4/2026 passed by the Court of Learned Civil Judge Senior Division Number 1 in Miss J case number 206/2026 arising out of title suit number 420/2025, whereby the present appellant was injuncted from using the excise license which was in the name of the present respondent and not to pose as authorized representative of
No respondent.
the respondent.
Who's
So
the license holder?
the plea of the appellant, the main ground taken by the appellant in this appeal challenging the impugned order is that he was not heard while passing the impugned order by the trial court. Stop. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Let the records of Ms. J case number 206/2026 along with the scanned copy of the records of title suit number 420/2025 be called for from the trial court. Registry to take steps for requisitioning the records. Since Mr. S.R. Gogoi has already appeared for sole respondent, no formal notice need to be issued to the sole respondent. Let this case be listed on 3rd of June. The connected caveat stand discharged.
And in the meantime, my lord, the impugned order may be received.
No. We'll examine.
My lord, that is, I have to place my.
You,
Because I will not be able to run the wine shop myself.
you have
My lord will.
filed an IA. Along with this appeal, any IA is there, separate IA.
Separate I is.
You have to file a separate IA for interim prayer.
Sometime you file, sometime you don't.
No, you follow the rule. You file separate IA.
Very big prayer in this, I appeal memo. my lord.
Know what rule says?
Order for the speaker about our separate IMI. We can file it, see, in all cases, I am filing the way I'm. So far it relates to MACT is concerned.
So is it left to the good discretion of the petitioner?
Lordship, my lord.
Then no, you go through the High Court rules. So, interlocutory application is necessary when you are seeking an interim relief in an appeal. File the IA. List accordingly.
Till then, my lord, I will file it tomorrow.
Then we'll decide tomorrow. You can file it at any time.
Item 11. Awesome, like.
Get matter, your lordship will take up this matter.
No, if you file an IA, it will be listed. You give notice to the other side and then file so that he gets notice of the case. We'll decide your IA when it is before the court.
My lord, let it be Friday, my lord, in the meantime, I'll file.
No, we are fixing the appeal in its due course because we have called for the records. But if in the meanwhile, if you file an interlocutory application, it will be taken up for hearing.
I'll make a mention.
Obliged.
If you.
The present appeal is referred under section 23 of the Act challenging in judgment passed by the unit. Lordship at the stage investigation and what.
Third, Miss U. Bihani, learned counsel for the applicant.
Appearing behalf of PS Law Firm.
Also, Miss, what is your name? N. Das, appearing on behalf of Mr. P.S. Lakar, learned Central Government Council. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been preferred by the appellant, impugning the judgment and order dated 26/2/2026 passed by the Railway Claims Tribunal, Gauhati bench in original application number 3, Roman 3 dash 28/2023. I have gone through the grounds stated in the memo of appeal. This appeal is admitted. Issue note, since Ms. Das has already appeared for the respondents, no formal notice need to be issued to the respondent. Let the records of the original application number -3 -28/2023 be called for from the Railways Claims Tribunal, the registry to take steps for requisitioning the records. Let the matter be listed on 5th of June. Same order, original application number different homo, ek order.
Item 14.
Yes, Ms. Bihani, you are in this case also, item number 14. Same order. Don't show the name of other side. Tat likhibo. The notice has, as the notice has already been served on the Deputy Solicitor General of India, no formal notice need to be issued again. Baki eke thake. Date 15. 15 also said.
Item 16.
On quantum basic application of a break of a side, patient like was award, considering the loss of income is
But Mr. S.K. Goswami, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 2012-2021 passed by the Motor Accident Claims Tribunal, Gwalpara, in MEC case number 321/2017. The appellant is basically agreed with the quantum of compensation awarded to the claimant's respondents. This appeal is admitted. Call for the records of MEC case number 321/2017 from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps. No, issue notice to all.
So their name may be shown in the court list. Lordship may pick this matter another also. They have already appeared.
Which I condonation.
Already appeared. They have made the name of the respondent for clear has been shown. And 1 and 2 notice have issued. In the cause this also clear full name will show.
But in the main case, they are entitled to get fresh notice.
Even name has been shown. If they start post, then they will delay it also. Which are the copy to respondent 3 and 4. And look at appearing for respondent 3.
The learned counsel for the appellant submits that in the connected interlocutory application, which has already been disposed of, the respondent number 3 and 4 have been represented by their engaged counsel, and Their names are also reflected in the cause list, and therefore submits that he further submits that he will serve the notice personally to the learned counsel for the engaged counsel for respondent number 3 and 4. Stop. Prayer is allowed. As regards other respondents, namely respondent number 1 and 2, let the notice be issued. The appellant shall take steps for issuance of notice on the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of June.
Stay petition is there, deposit 50%. Already stay order stay has been granted in ILOC, directing us to deposit 50%. They will deposit 50% of their work to be released also.
Stay petition, there is no order.
The continuation petition, court has passed this order, depositing 50% of their work.
In the
The continuation petition, delay continuation petition, honorable court has recorded that 50% will be deposited. Because there is a huge delay of 1,144 days.
heard Mr. S.K. Goswami, learned counsel for the applicant. This application, this interlocutory application has been filed by the applicant insurance company in connection with MAC appeal number 122/2025, praying for stay of execution of the judgment and award dated 20/12/2021 passed by the Motor Accident Claims Tribunal Gwalpara in MSC case number 321/2017. Learned counsel for the applicant has submitted that in the connected MAC appeal, the present appellant had also filed an application for condonation of delay in filing the said appeal. The said condonation application was allowed by a coordinate bench of this court by its order dated 2/3/2026, passed in IA civil number 2245/2025. He submits that in the said application, in the said order itself, the appellants were directed to deposit 50% of the awarded amount to the registry of this court. He submits that the present applicant is ready to deposit the 50% of the awarded amount as was directed by the coordinate bench of this court. He also submits that the present interlocutory application may be disposed of in light of the order passed by the coordinate bench of this court on 2/3/2026. Stop. Since the applicants are willing and ready to deposit 50% of the awarded amount as a condition of granting stay of the execution of the impugned judgment and award and have considered the submissions of learned counsel for both sides. Learned counsel for the appellant. This appeal is admitted. Let the records of the MSC case number 1547/2018 be called for from the concerned tribunal. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of June.
Let them.
Item 19.
এটা requisition দিব door stopper আজিয়ে দিব সবাই দিব আজি yes heard Mr. K.K. Bhatta, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been filed by the National Insurance Company Limited, impugning the judgment and award dated 18/12/2025, passed in MSC case number 331/2018 by the Motor Accident Claims Tribunal, Gwalpara, whereby the appellant insurance company was directed to pay a compensation amount of rupees 10,42,000 along with an interest at the rate of 7.5% per annum to the respondent/claimant. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MSC case number 331/2018 be called for from the concerned tribunal. Registry to take steps for requisitioning the same. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 20.
ইয়ার পিছন মাই 1 মিনিট কান নামি Mr. P.J. Burman, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the National Insurance Company Limited, impugning the judgment and award dated 29/1/2026, passed in MSC case number 300/2022 by the Motor Accident Claims Tribunal, Gwalpara, whereby a compensation amount of rupees 2,50,000 was awarded to the claimant respondent along with an interest at the rate of 6% per annum. What is your ground of appeal?
There are 2 vehicles involved and the liability has been fastened against our vehicle
Only.
only. But Rishi was driving his own vehicle and that owner insurer was not made a party in that case. But as per the clear provision of 164, the person who was actually in use of the vehicle is liable. The insurance on the owner is liable.
Let the records of MSC case number 300/2022 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. Let the notices be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June. We are issuing notice. In stay application issue notice. I'm taking a short break.
Please, Your Lordship. Lordship, service report will be awaited in respect to respondent number 2.
When have you taken steps?
2nd of April 26.
Okay. Heard Miss M.
Second.
Dev, M. Sakya, London Counsel for the appellant. Also heard Mr. M. Hussain appearing for respondent number 1 on perusal of the office note dated 24/2026. It appears that the service report in respect of notice issued to respondent number 2 is awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post, before this court on the next date fixed. Let this matter be 15th of May.
Authorized, Lordship.
Item 24.
For last order, noticing to issue and the appeal is admitted. And for office note dated 1/4/2026, the service report and respondents are complete.
Are awaited. Complete.
Matter may be fixed for hearing.
The
Office note dated one-
records of the trial court have arrived. Heard Mr. S. Sharma, learned counsel for the appellant. None appears for the respondents. Though office note dated 1/4/2026 shows that the notice issued to all the respondents have been duly served. This appeal is therefore ready for hearing. Release this matter for hearing on 16th of July.
Item 25. Also, the matter may be passed forward to the time. Like conducting counsel has went upstairs.
Okay, what is the key matter, sir?
May I please, Lordship? Here, Lordship, the service upon the respondent number 3 is not here. But we have taken dusty upon the respondent number 3. And I have the instruction that it has been duly served, but we are not able to file the affidavit since the local office has not yet sent
You'll be filing.
Lordship, I can mention that, Lordship, we want to settle this case amicably. And the respondent number 1 might not have the means to engage the lawyer, Lordship. My humble submission is that the pro bono lawyer will be engaged, Lordship, and we can go for settlement of this case. In that regard, Lordship, respondent number 3 is not required. Although dusty has been served, but we are not able to file the affidavit because the original acknowledgement is not yet received in the original office, from the local office.
None
None has appeared in this. None has. There are 3 respondents. None. Respondent 1 and 2 are the parents.
On the next date, you submit the dusty affidavit in dusty. In the meanwhile, we'll engage one.
Lodge. And matter may be referred to the upcoming local lawsuit.
When it is fixed.
I have received the email today to submit the list of.
लोक अदालत की इतिहास है.
The next local lawsuit.
We'll fix a short.
Beneficial result, we don't want to file in this case.
Then you withdraw the appeal.
My clear instruction is there, they want to amicably settle.
Okay. Heard Mr. P.J. Burman, learned counsel for the appellant. None has appeared for respondent number 1 and 2. However, on perusal of the records, it appears that the notice were duly served on respondent number 1 and 2 by Dusty Mode. Learned counsel for the appellant also submits that the notice has also been served by Dusty Mode on respondent number 3. However, he seeks some time to file an affidavit in compliance thereto. He also submits that the respondent number 1 and 2 being
They reside in a remote area, so in a tea state, as per my instruction, and they are very poor.
being very poor may not be in a position to engage any counsel on their own. He further submits that the appellant is ready to amicably settle the matter with the respondent claimants. However, hence he submits that a legal aid lists some civil or civil. Hence, any amicus curiae present in the court. Yes, hence Miss R.D. Majumdar is hereby appointed as amicus curiae to defend the cause of respondent number 1 and 2 in this appeal. The appellant is directed to furnish a copy of memo of appeal to the newly engaged amicus curiae for respondent number 1 and 2. The registry is also directed to reflect the name of Ms. R.D. Majumdar as amicus curiae for respondent number 1 and 2 in this appeal. List this matter again on 22nd May. When is the Lok Adalat?
There is nothing, we feel a specific order that it may be listed on the next law, so we can.
Next Lok Adalat is on 9th.
9th of May. So we may be listed also. We can.
Maybe it can be listed.
No, if there is an amicable settlement reached,
We are ready.
because she will have to contact the respondent.
We can assist Lodge.
Then even we can pass orders on settlement, even in normal court, even if it is not
Yes.
listed in Lok Adalat.
Yes, it can be settled in court order itself.
Yes.
But then representation, what their stand is, I have to know that much to represent them.
So let it be fixed on 22nd of May.
In the meantime, he'll provide me the phone number or whatever.
You assist.
Yes.
Obliged.
Item 26.
May I please, your lordship, service is complete, my lord. Reminder should go for LCR.
Or maybe for respond number 1.
Heard Miss L. Sharma, learned counsel for the appellant. Also heard Miss P. Barwa, appearing for all the respondent number 1. On perusal of the office note dated 30/4/2026, it appears that notice from where you are saying service is complete.
Please lead us for this phone number.
Okay. Learned counsel for the appellant submits that since name of Ms. D. Das has been reflected in the cause list as engaged counsel for respondent number 2, the appearance of parties in this appeal is complete. She submits that only the trial court records have not been received. Stop. Issue reminder for trial court records. Registry to take steps for issuance of reminder. Let this matter be listed again. 6th of June. 5th of June.
Item 27.
Ms. Chaudhary, you are appearing for
For 3, Lordship.
3. Who is appearing for 2?
They are not here, Lordship. Was listed as a
Miss, what is your name? M.
A Burma.
A. Burman, learned counsel for the appellant. Also Miss M. D. Chaudhary. Miss M. Chaudhary, learned counsel for respondent number 3. On perusal of the office note dated 29/4/2026, it appears that the service report in respect of notices issued to respondent number 1 is awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 1 by speed post on the next date fixed. Let this matter be listed again on 15th of May.
Obliged, Lordship.
Item 28.
Yes.
Okay. I have some submissions to make. So, on 19/12/2025, an order was passed in the IA 3719. And before that, there was a hearing that was conducted, and in the hearing, they had placed 2 facts, 2 important.
Why this matter is listed in orders column today?
Because they have to.
We have to
sub-
file,
yes.
we have to file another IA or 2. So therefore, I'm coming here. They said that they will not file any execution case until the disposal of this appeal. And they also said that the fact that Rumi has changed her father's name, she has fraudulently changed her father's name to claim to be the daughter of Jitendra Bonikka, is not taken up in the previous appellant or the trial proceedings. Both the 2 things have gone wrong now. They went and filed an title execution 11 of 2026 in the month of February, while we were still gathering the certified copies. And in that title execution, they failed to mention that the appeal was pending.
No, there is no bar in filing.
Within 2 years, they didn't give us notice, but here they had said orally that they will not do it. They had submitted in this court, I was there, that they will not file an execution case until
But
a decision from this court had come. So now when we file for a stay, That's Civil Judge Junior Division of Abhaya Police. Now she wants us to file a I here, get a stay and file it tomorrow. So I beg your leave to file an interlocutory application for stay of the matter, for stay of the execution. Meanwhile, we have made very good progress with the circle officer, who has also issued notice for cancellation of the next of kin certificate, which was fraudulently obtained, and the other fraudulently obtained documents as well. And note 5th of May is the date of appearance. Not only that, Rumi didn't appear in this matter, but she went and filed the execution. So many notices have gone, so many IAs have been filed. They have received the notice of all of that, but she didn't bother to file anything in the High Court. The criminal case is pending. She didn't come and appear there.
What is the submission here in this REC?
We just
You're seeking adjournment for filing an I. That is a
for seeking stay of the matter. That is my submission.
You have any objection?
Yes, Your Lordship. We will, my senior is on leg, so that's why.
Meanwhile, we have also filed the nullity because they have filed the.
No, you could have filed the IA by this time.
We didn't get the certified copy of the the petition they filed for the execution because no notice was issued.
Heard Miss A.S.I.K. Learned Counsel for the appellants. Also heard Miss S. Pal.
Appearing on behalf of Mr. B.J. Mukherjee.
Appearing on behalf of Mr. B.J. Mukherjee, Learned Counsel for the respondents. Learned Counsel for the appellants has prayed for an adjournment as the appellant intends to file an interlocutory application seeking stay of execution of the impugned judgment during the pendency of the current pendency of the instant regular second appeal. How much time you want?
Filing by tomorrow. If we get it tomorrow, we'll file it by the other tomorrow. So not that much time. We are all ready with the other documents.
And the prayer is allowed.
Any date fixed by the court should be after 5th of May, when we want to know if she appears in before the circle officer.
Prayer is allowed. May last. Let this matter be listed again on 29th of
Item 29.
Regular first step is referred by challenging judgment degree, whereby OPD is directed to pay compensation of 20 lakhs 77,000. So there is delay of 25 days in that bill.
You're objecting? Heard.
On behalf of 1 to 5, respondent number.
3 and 4 are the.
1 to 5.
You're appearing for one to, how many respondents are there?
That's 8. 6, 7 and 8, they can be represented by the government advocate because the headmaster is a party and the electrical inspector.
Have you served notice on them?
Yes, Lordship. In fact, on one occasion, the government advocate appears already.
3 and 4 are the minor daughters of respondent number 1.
No, she's appearing for all.
She is appearing for
1 to 5, yeah.
with how to ascertain the stand of government, because there was a direction for reflecting the name of government advocates in the cause list.
Not,
That is not reflected.
will inform the government.
We'll take it up tomorrow or in the second half, because she is conceding.
That's
In the meanwhile, you inform.
it.
Okay.
Item 30.
May I please, Your Lordship?
Yes.
Item 31 and 32.
But application has been filed for correction of one error, my lord, in the order passed in the review, my lord. That correction is at page 53, correction requires correction. my lord.
Page
53. Paragraph 21. Accordingly, the lordship got it.
Yes.
Accordingly, the impugned order dated so and so passed in IA number so and so is reversed, and the said interlocutory application is accordingly dismissed. So in case of dismiss, it requires restored. Because once review is allowed, my lord, under order 47, rule 8, it is to be required to be restored, then it is to be decided afresh.
Yes.
This dismissal part only is required to be restored.
And reverse part,
Yes, my lord.
reverse part,
Reverse part, it will be decided because I.
no, it cannot be reverse. It has to be vacated.
Yes, it is.
It has to be vacated.
But only vacated. Vacated and it is accordingly restored.
Is there any observation that review application is allowed?
This is the this order is likely that
Yes.
paragraph 20.
My lord, first of all, the review petition is not lie as per order 47 rule 9, which we have.
No, this is a review application.
My lord,
Yes, review on review application.
Yes, sir. But it's kindly see the last order. Under order, under section 151 and 52 of the CPC, my lord.
Yes, this cannot be treated as review against an order passed in review does not lie.
And see last observation made. And in this application, I have specifically mentioned about or under 151. And 152 also, my lord, attract.
What is 152?
152.
Read 150.
Only for arithmetical error, my lord.
Read completely.
Yes, complete reading is required.
Amendment of judgment, decree or orders, clerical or arithmetical mistakes in judgments, decrees or orders or error arising therein from any accidental slip or omission may at any time be corrected by the court, either of its own motion or on the application of any of the parties. In this regard, my lord, I have some citations, then 152 may not entertain in this regard, my lord. I have 3 citations in this regard. And first, thing is that, my lord, as per order 47 rule 9, review is not applicable. This
No,
is not a proper form, my lord. And regarding post title,
No, can this be treated as an application under
No,
151?
no, my lord.
Why not? That you have to satisfy. Review does not lie, that I am agreeable. But there is an apparent error.
See, order 47, 8 first. Order 47, would be.
Yes.
When an application for review is granted, a note thereof shall be made in the register, and the court may at once rehear the case or make such an order in regard to the rehearing as it think fit.
No, that is also clear.
It is clear.
It
that
is clear that
the application is to be reheard.
there is an apparent error.
Yes. So rehearing is required, my lord, with respect to the IA which has been.
Judgment under review.
Yes, and it was reversed. The order reflects that the decision has been reversed. That judgment I have brought, the decision cannot be reversed, it can be reheard if it is allowed.
No, if review is allowed, the order under review is to be vacated
Vacated.
and the matter is to be reheard. That is the procedure. And there is an apparent error. Yes,
if there is an apparent error, then why 5 years later in delay? Why during pendency of the review petition 90 of 2000 earlier review petition, why they did not produce the compromise agreement?
No, no, no. We are not on those questions.
In this, they have to approach
Apex Court.
Yes, SLP by SLP. If the petitioner agree of the correctness of the order, they are only legal remedy in a SLP to the Supreme Court, not a second review petition. Secondly, this is a request for rehearing, which is strictly prohibited. The petitioner is essentially challenging the correctness of the court's finding, my lord.
No, no. In this, if you go through the order dated 15-9,
Review order.
Review order. The review was allowed, but the observation, the finding was that the order under judgment under review was reversed, which review court cannot do. And
then they may file a
SLP.
They may file a yes SLP, or for the correctness of the of that order, they may file appropriate application for that. But this review petition at least may be dismissed, and I will file objection in this regard if they file IA for correctness of the order.
No, no. Their submission is that treat this not as a review petition, but as a you may file an application to that effect.
Section 50,
151 has been mentioned.
my lord, section 152 CPC is limited to clerical or arithmetical mistakes.
Yes, on that I may give.
Section 152 of the CPC cannot be used to make substantial judicial alterations or modify substantive findings of the judgment. Altering a party designation or the statutory provisions of final petition touches upon the substantive right of the parties rather than rectifying an accidental slip or omission. I have citation in this regard, my lord.
Give me the citation.
Dwarika Das, I have 3 citations.
Your reply?
I have also short submission. In Dwarika Das, the Honorable Supreme Court held that Section 152, para 6 maybe, my lord. There are 6 in Dwarika. The Honorable Supreme Court held that section 152 cannot be invoked to make substantive amendments to judgment that have attained finality on merits. The section cannot be used to substitute or alter the conditional post title after the decree has attained finality. And second judgment, Joya Lakshmi.
Jayalakshmi, I am also reading.
Para
Paragraph 13.
14 and 15, my lord.
Para 13.
The Supreme Court ruled that the error must be one which the court inadvertently made. It does not contemplate correcting judicial error or changing the substantive nature of the cost title.
Para 13 and
14.
So far, legal
But ha-
position is
14
concerned,
and
there
15,
would
my
hardly be any doubt about the proposition that in terms of section 152 CPC, any error occurred in the degree or on account of arithmetical, then or clerical error or accidental or
where are you reading?
paragraph 13. Para method
Para 14 and
13.
14 and 15.
Question.
Yes, so far as legal, read again.
Legal position is concerned, there would hardly be any doubt about the proposition that in terms of section 152 CPC, any error occurred in the degree or degree on account of arithmetical, then or clerical error or accidental slip.
So you want to say that
This
this
is
error
the
is an accidental
accidental
slip?
slip, yes, or slip may be rectified by the court. The principle behind the provision is that no party should suffer due to mistake of the court, and whatever is intent by the court while passing the order or decree must be properly reflected therein. Otherwise, it would only be destructive to the principle of advancing the cause of justice. A reference to the following cases.
Dwarika judgment. Will be judgment of the learned council has not.
Yes.
So far legal position is concerned, there would hardly be any doubt.
No, my query is 3 kinds of mistakes may be rectified. Arithmetical error, clerical error, or accidental slip. His submission is that error which this court has committed is an accidental slip. On that, what is your submission?
But the petitioner has proposed to convert the petitioner review proceeding into an application under section 152 of the CPC and revive IA. Earlier submission of that. IA may be revived. This objection is filed to place on record the legal impermissibility and jurisdictional bar of such a.
No, not revive IA. You want to revive the RSA?
RSA was
No.
already revived, my lord.
First,
If the IA,
RSA has been revived. Then
IA.
IA is to be revived.
if
Because, let me say, because under order 23, rule 3, it is a separate proceeding, my lord, independent of the RSA or all these things. So since it is an independent proceeding, it should be heard first, whether there was any the ground which has been shown that at the time of filing of this, one document has not been
Okay.
annexed.
You have some more submission?
yes,
How
reviving,
long will you take?
yes, reviving the IA
No,
direct.
if you are going to take some time, we'll continue after lunch.
Obliged.
We'll continue after lunch. At 2.
I'm sorry, Mr. When I think number 14 was been called. See, I was on lake since some other call. I'm referring for the sole respondent. So, Lordship may kindly record my
Item
name.
number 14.
CKS.
CKS Barua, show the CGS. Central Government Council, show his name. Yes.
My lord, there is no accidental slip on the part of the court when the order was passed. It is that the order dated 59/2025 is a considered reasoned judicial order disposing of the dispute on merits. There is no accidental slip, omission, clerical or arithmetical error within the meaning of section 152 CPC. The present petition is not seeking the correction of an inadvertent ministerial error, but it is attempting alter the substantive findings of the order. It is well settled that the jurisdiction under section 152 cannot be invoked to reopen the merits of the case or to introduce new findings, and the remedy of review, if any, is governed strictly by the provisions of order 47 rule 1 CPC. Therefore, the present review petition may be dismissed. This is my submission, and para 6 in the Dwarika judgment, my lord, if may peruse, I have already been submitted. 1999 3 SCC 500, page number 500. Para 6, my lord. In this judgment, it is very clear. Scope of section 152 of the, and as per order dated 13, this honorable court on the last occasion, if my lord may peruse last order, they already admitted that this application wrongly filed under section 151, and they want correction to file an application under section 152. And in this regard, this review petition may be dismissed as to which because my lord, order 47 rule 9 is clearly prohibited the non-review, for which they may file a proper application, my lord. Proper I may be filed if they want. Then I will file an objection in this in that IM, my lord, if they file. But this review petition is totally barred under as per order 47 rule, and there is no arithmetical error, my lord. And para 6, my lord, section 152 CPC in Dwarika judgment, if my lord may peruse. Section 152 CPC provides for correction of clerical arithmetical mistakes in judgment, decrees or orders or errors arising therein from any accidental slip or omission. The exercise of this power contemplates the correction of mistakes.
You have already submitted.
Yes, but this application is not filed under section 152, my lord. 151, they have filed an application, for which this, at least today, this review petition may be dismissed.
Heard Mr. S.K. Ghosh, the learned counsel for the petitioner. Also heard Mr. What is your name?
A.K. Hannan, my lord.
A.K. Hannan, learned counsel for the respondent. This application under order 47 read with section 114 and section 151 of the Code of Civil Procedure, 1908, has been filed by the applicant seeking corrections in judgment and order day. Where is the impugned?
Impugned order is page 44, Annexure 7.
Judgment and order dated 15/9/2025 passed by this court in review petition number 90/2020. It is pertinent to mention herein that the review application, the review petition number 90/2020 was filed by the present petitioner and was filed by the present respondent under order under section 114 of the Code of Civil Procedure, seeking a review of the order dated 26/6/2020, passed by a coordinate bench of this court, within bracket, Honorable Mr. Justice P.K. Deka, bracket close, in IA within bracket C number 947/2020. Learned counsel for the petitioner has submitted that the aforesaid review petition within bracket review petition number 90/2020 was allowed by this court. However, instead of restoring instead of vacating the order dated 26/6/2020, passed in IA Civil number 974/2020, and restoring the said interlocutory application for rehearing, in the operative portion of the aforesaid order, that is in paragraph number 21, it was stated that the impugn order dated 26/6/2020, passed in IA Civil number 974/2020, is reversed, and said interlocutory application is accordingly dismissed. Stop. Learned counsel for the petitioner submits that in view of the provisions contained in Order 47, Rule 8 of the Code of Civil Procedure, in event of allowing a review petition, the order under review has to be vacated and a date has to be fixed for rehearing of the matter in which the order under review has been passed. He submits that in paragraph number 21 of the order dated 15/9/2025, passed in review application number 90/2020, the words within inverted comma reversed and the words dismissed within inverted comma are due to accidental slips made by this court. He submits that in place of the word reversed, the word vacated ought to have been used. In place of the word dismissed, the word restored ought to have been used. He further submits that though there is a bar against further review, though there is a bar under Order 47, Rule 9 of the Code of Civil Procedure against further review of an order passed in an application under Order 47, Rule 1, comma, he submits that there is no bar on rectifying clerical error, comma, clerical error, comma, arithmetical error, comma, or an error which has occurred due to accidental slip. Hence, he submits that this, though this application was filed by the present petitioner under Order 47, read with Section 114 also, it may, for the ends of justice, it may be treated as an application under Section 152 of the Code of Civil Procedure, read with Section 151 of the said code, and the accidental slip which has crept in the paragraph number 21 of the aforesaid order may be rectified. He submits that it is a settled proposition of law that in event of allowing of an review petition, the order under review has to be vacated and the case in which the order under review has been passed has to be restored for the purpose of rehearing on the matter. In support of, he further submits that the provision under Section 152 has been interpreted by the apex court in the case of Jayalakshmi Coelho, Coelho versus Oswald Joseph Coelho, reported in 2001 4 SCC 181 as any error as last line क्या लिखा? No, read from the starting of that line. as that in terms of section 152 of the Code of Civil Procedure, any error occurred in decree on account of arithmetical or clerical error or accidental slip may be rectified by the court. On the other hand, Mr. Hannan, learned counsel for the respondent, has vehemently opposed the prayer made by the petitioner on the ground that there is a clear bar in order 47 rule 9 of the Code of Civil Procedure regarding any application to review an order made on an application for review or decree or order passed or made in a review. He submits that the rectification which is sought for by the present petitioner will touch upon the merit of the case, and it will not be confined to any, if allowed, it would not be confined to any clerical and arithmetical error. He submits that even the scope of section 152 and which para you are relying? Dwarkadas case, which
Para
para?
6, para 6.
Even if it is interpreted liberally, would allow the court to only rectify clerical and arithmetical mistakes and would not contemplate passing an effective judicial order touching upon the merit of the case after passing of the decree. He submits that after passing of the judgment and decree or order, the court becomes functus officio. He submits that even if there is any error in the order dated 15/9/2025, passed by this court in review application number 90/2020, the appropriate remedy is to file an appropriate application before higher court. And not before this court. In support of his submission, he has cited a ruling of the apex court in the case of Dwarka Das versus State of Madhya Pradesh and another, reported in reported in 1999 3 SCC 500. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. On perusal of the judgment and order dated 15/9/2025, passed in review petition number 90/2020, it appears that the said judgment and order is a detailed judgment and order giving reasons for allowing the aforesaid review petition. However, it appears that while allowing the review petition, this court, in paragraph number 21 of the said judgment, had directed that the judgment under review, that is directed that the order under review, that is order dated 26/6/2020, passed in IA civil number 974/2020, is reversed within inverted comma, and the interlocutory application was dismissed, which is apparently an error contrary to the provisions contained in Order 47, Rule 8 of the Code of Civil Procedure. Said, this court is of considered opinion that as to what would happen if a review petition is allowed has been provided for in the statute itself. The provisions contained in Order 47, Rule 8 very categorically states that in the event of allowing of a review petition, a note thereof shall be made in the register, and court may at once rehear the case or make such an order as regards to the rehearing of the case it thinks fit. Thus, there is no doubt in the legal position that in the event of allowing of a review petition, the matter in which the order under review has been passed has to be reheard. This court, therefore, regards the words reversed within inverted comma and dismissed used in paragraph number 21 of the order dated 15/9/2025, to be an accidental slip which is required to be rectified. Stop. As regards which is required to be rectified. Stop. Stop. Since there is a bar provided under Order 47, Rule 9 of the Code of Civil Procedure in filing an application for review of an order passed in a review petition, this court is treating the instant interlocutory application as an application under Section 151, read with Section 152 of the Code of Civil Procedure, instead of an application under Order 47 and Section 114 of the Code of Civil Procedure. The registry to rectify, registry to re-register this case as a renomenclate this case as miss case under Section 151, read with Section 152 of the Code of Civil Procedure instead of review application. Stop. In view of the discussions made and reasons stated in the foregoing paragraph, the error occasioned due to accidental slip in paragraph number 21 of the order dated judgment and order dated 15/9/2025 passed in review application number 90/2020 is hereby rectified, and the word reversed in paragraph number 21 of the aforesaid order shall be read as vacated, and the word dismissed used in the said paragraph shall be read as restored. Stop. Accordingly, the interlocutory application number IAC number 974/2020 is hereby restored. The registry shall list the said IA for re-hearing on which date?
A short date may be given.
20 May.
I have another submission, my lord. The IA, if revived, then it directly contradicts the review order, my lord. They have filed this IA for that compromise was.
No, IA will be heard again.
If IA will be heard, my lord, then.
That is the law. IA has to be heard. Review is allowed on date on 20th. You can make all submissions during rehearing. Fix on 20th of May.
Pleasure.
Bail.
Attend hold.
None appears for the appellant on call. List this matter after a week on a date to be fixed by registry.
Item 22.
My lord.
Yes.
My lord, I have perused the law, my lord, and my lord had asked me a question before the break, whether under section 35, is there any procedure to the service of notice, my lord? Now, my lord, I have seen the law in this regard, my lord, and this question has been in a manner has been dealt by Satyendra Kumar Entil in 2025 7 SCR 1858. My lord, before proceeding, my lord, let me candidly submit, my lord, there is, as per section 35, there is no procedure as to service of notice means they do not specify how the notice is to be serviced. In this case, my lord, there was a question arise before the Supreme Court. Can under section 35 notice be served through electronic medium, my lord? The Supreme Court has said, after analyzing the law in para number 26, I can directly take this on the
No. You first
Yes, my lord. Yes.
answer my query. In this case, the
Hello.
case of the petitioner is that
My lord.
offense involved is punishable with a punishment less than 7.
Provisions of 63, 67 or 66, my lord, is a case where inquiry has been conducted by the court.
But
Now,
when no provision is there as how to
then
serve someone, this can be taken recourse to.
this can be taken recourse, but my lord, how Supreme Court in the same case, my lord, has looked into these provisions also, but in a little different context. My lord will see para number 31. Now, context in para number 31 of the judgment, my lord, was summons can be served electronically. Can the notice be served also electronically? That was Supreme Court was trying to find out.
Yes.
Supreme Court from para number 31 has said analysis is there in para number, my lord, 41 directly the analysis is there and 42. But Supreme Court has said, my lord, that cannot be done.
That cannot be done.
That cannot be done. You cannot serve section 35 notice electronically.
Okay.
But that is the reason, my lord, I am saying, if police can demonstrate that they have taken steps to protect his substantive rights, that they have gone there, they have maintained a diary, that they have gone there, they have tried, they were not there. Because it is the admitted position on the part of the petitioner, my lord, that they were not there at their residence. Now, police can be given an opportunity in this case, my lord, if my lord thinks proper, to serve this summons.
No, that opportunity was given
The last
on the last occasion.
Still, my lord, by law is this, my lord, if non-service of summons also does not allow police in this kind of cases to arrest. That is what I've seen, my lord. That court was repeatedly saying that there has to be attempt by the police to preserve this.
He cannot be arrested without.
He cannot be arrested, my lord, without the service of
So
summons.
there is no apprehension of getting arrested without getting notice under 35.
That, my lord. That, my lord, that interpretation, my lord.
Where are you now staying? Where summons can be? Because this aspect has been dealt with in the last order.
Last order, my lord. That my lord has.
You have not come up with any new case.
It was placed for lordship in my petition where I have stated lordship that I was not in the house, not whole family is why absconding. But I have stated in paragraph 6, lordship, may I read?
No, there is no need to abscond. In these kind of offences, you may not be arrested.
May not be arrested.
Case registration, police have arrested the accused wife in bailable section and forwarded to judicial custody. And they have She got bail on 13/10/2025. After 50 days, Lordship may kindly bear space 5. She was arrested from house, one mobile phone.
No, her case is a different case.
Lordship, that is different, but she was there in the house, so notice can be served that time, Lordship. And one mobile phone was also seized from house.
No, suppose now you are arrested without serving notice under 35. That may be a good ground for you to get bail. But that may not be a good ground for getting anticipatory bail.
I also like to point out that.
That was the observation.
Submitted one judgment, Lordship may kindly bear over. Prohibitions versus State of MP, Lordship. In the second phase, first paragraph, may I read, Lordship? Prohibitions, I have submitted in morning, Lordship. We have an extra copy.
Yes.
However, looking to the fact, since the offense is question attack punishable up to 7 years thereof in view of the principle laid down by Commission, so it is directed in the offense involving up to 7 years punishment. The police may resort to the extreme step of arrest only when the same is necessary. The petitioner, if the petitioner does not cooperate in the investigation, the petitioner should first be summoned to cooperate in the investigation. If the petitioner cooperate in the investigation, then the occasion of arrest should not arise, Lordship. Similar case, Lordship, it was anticipatory bail application, 7 and 8 POCSO was there, Lordship. 3 to 5 years in my case also, Lordship, and I am a subject, sir, 59 years old, Lordship. And I have got enough.
So what was the order passed in that case?
Bail was granted.
Have informed the government. Taking code number 7, and in fact, I had a phone call to Mr. SS, who is the governor. He informed me that his name may be recorded in the order.
Heard, Mr. This is item number? Heard, Mr. Arbora, learned counsel for the applicant. Also heard Miss B. Sarkar, learned counsel for the respondent number 125. 1TO25. Echo purpose. 125. It also appears that though by order dated 27/5/2025, the name of the government advocate Assam was directed to be reflected in the cause list as counsel representing respondent number 6 and 8. However, same has not yet been done by registry. Registry is directed to comply with the order dated 27/5/2024. Stop. Mr. Bora, the learned counsel for the applicants, has however submitted that he has informed Mr. SS Royal, the learned government advocate, who is on his legs in a different court, and who has intimated him that he does not have any objection if the present interlocutory application is allowed and delay of
25 days.
25 days is condoned. Stop. This interlocutory application has been filed by the applicants under Section 5 of the Limitation Act 1963. Praying for condonation of delay of 25 days in filing the connected regular first appeal wherein the present applicants have impugned the judgment and decree dated 4/11/2023 passed by the Court of Learned Civil Judge Senior Division Hailakandi in money suit number 10/2019, whereby the present applicant were directed to pay a compensation amount of rupees 20,77,500 to the respondents. Respondent number 1, 2, 5 within a period of 3 months from the date of decree, along with an interest at the rate of 6% per annum. Learned counsel for the applicants have submitted that why there was delay? Where is the in which that the reasons for approaching the court beyond 25 days of the prescribed period of limitation has been stated in paragraph number 4 and 5 of the instant interlocutory application, and same may be considered as sufficient grounds under section 5 of the Limitation Act. Ms. B. Sarkar, Learned Counsel for the respondent number 1 to 5, submits that considering the grounds shown by the applicants in the instant interlocutory application, she does not have any objection if the delay of 25 days is condoned. Stop. After considering the submissions made by Learned Counsel for both sides, and after going through the reasons stated in the paragraph number 4 and 5 of the instant interlocutory application, this court is of considered opinion that the applicant is able to show that he was prevented by sufficient cause in approaching this court by filing the connected appeal within the prescribed period of limitation. Stop. Accordingly, the delay of 25 days in filing the connected appeal is hereby condoned, and this interlocutory application is accordingly allowed. The registry is directed to register the connected regular first appeal and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly disposed of.
Appeal kindly serve. Appeal will.
Serve the appeal, memo of appeal.
Yep, right.
Item 43.
Under the introduction of appellant company, I make sure withdrawal of this. In this regard, this company has provided.
Okay, your way 33 is, what is your name? Heard Mr. R. Busha, Learned Counsel for the appellant. Also heard Mr. S.C. Bishwas, Learned Counsel for the claimant respondent. Claimant respondent. Learned Counsel for the appellant submits that he has been instructed by the appellant insurance company to withdraw this instant appeal. Stop. The prayer is allowed. This appeal is dismissed on withdrawal.
But only one prayer to add, brother. They have till today not deposited any amount.
No.
So there is no stay order from the High Court.
Now there is no appeal. Appeal is dismissed.
That's true, my lord. So
They
will
have.
again delay, my lord, the matter.
Then you go for execution.
Sure.
The connected eye is also disposed of.
Item 44.
this one about one and two complete my lord. And three we have take again my lord instance of notice to by the mode of the state.
Heard Miss L. Sharma, learned counsel for the respondent.
Content number 4 maybe is my lord is not necessary. Challenging on only policy members.
Oh. 4 also it has been served. On perusal of office note dated 30/4/2026, it appears that the postal tracking postal track consignment report of the notices issued to respondent number 1, 2, and 4 have been shows that the notices were delivered to the addressees. Hence, the notice is on the aforesaid respondent is held to be duly served. Stop. However, notice on the respondent number 3 has not yet been served. Learned counsel for the appellant praised for allowing the appellant to take steps for issuance of notice upon respondent number 3 by Dasti mode. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 3 by Dasti mode within 7 days from the date of this order, returnable on 10th of June. In the event the appellant is able to serve the notice by Dasti mode, it shall submit an affidavit in compliance thereto on the next date fixed. Let this matter be listed again on 10th of June.
Item 45. Plus, I will 2866 of 25 has been filed by the claimant for modification of the order dated 21/3/22 passed by this honorable court. That is at page 11, relevant portion. The operation of the impugn judgment has been stayed, but without any stipulation for deposit of any amount. I'm praying for modification of this award and directing the
Where is that I? Where stay I? Stay I has been vacated, has been disposed of
yes,
without hearing you.
yes.
Hearing-
First date.
No, hearing me, I have filed the appeal, Lordship.
No, but without hearing the other side.
Yes, Lordship, without hearing, it was on the first date. Because Lordship, there is violation of policy condition as well as
But they are entitled to get.
Lordship,
a
then
hearing.
in the I, they have to send the notices because the other parties are not yet present here. In the I, they can take the step. Otherwise, finally the appeal can be heard. I have no objection on
This
that.
stage when I'm praying for only 50%.
No, Lordship, 100% they can get, not 50%.
She will pay 100%. We will modify it from 50% to 100%.
No, there is no 50%, Lordship. Total stay was given
You are
because of
ready.
our appeal.
You are ready to pay 100%.
After hearing, not
Okay.
before that. Because Lordship, in our appeal, Lordship, service R2 is served.
Now, how to deal with this?
This Lordship, two
Because
things are there first.
there is an apparent mistake of the
No,
code.
it has to be before the same court. That is the second part. First part is they have to take steps on the other respondents. They have made them respondents. And secondly, it has to go to that same court, Lordship. That same court will deal with that. That is the law. And thirdly, Lordship, my submission is that my appeal, because Lordship, R2 is served for 3 driver, not necessary at this stage. It can be heard. That 3 options are there, Lordship. I'm giving 3.
Because I was disposed of without hearing them.
So it has to be before the same court, Lordship. That is,
Whether I has to be restored.
it cannot be, Lordship. Lordship, final hearing can be done. That is the easiest way out. Because it is an appeal of 22. It is 26 now. Lordship can.
We will hear the appeal finally.
Yes.
Instead of, we'll give a short date
Fixed date
instead of.
that.
Though this interlocutory application has in IF 2866 has been filed by the applicant / claimant for to modify the order dated 21/3/2022 passed in IA Civil number 794/2022, whereby stay of the execution of the impugned judgment and award was granted by a coordinate bench of this court, and the IA was disposed of without giving any opportunity of hearing to the present claimant. However, considering the fact that this is the connected appeal, that is MAC appeal number 146/2022, is an appeal of the year 2022. This court proposed that instead of disposing of the instant interlocutory application, the connected appeal may be heard and finally disposed of. Both the learned counsel for both the parties are agreeable to the said proposition. Accordingly, let the connected MAC appeal number 146/2022 be listed for hearing on 11th of June. Huh? May it will be difficult. Let it be 11th of June.
Data payasa data. Lordship in the appeal lordship, service lordship can pass the order for service lordship.
Service is not complete.
No, for R2 it is complete lordship as per office note dated 3/9/25. R2 serve flag A. For service report of R3 not serve, addressee is from Kamrup district, the post usual record. Lordship 2 for the time being, 3 is not necessary for disposal because he is in a hurry. So for disposal of the appeal, 3 might not be necessary
So,
because owner is there.
Ms. Adi Majumdar, learned counsel for the appellant. Also, Mr. S. Datta, A. Bhattacharya, learned counsel for respondent number 1. On perusal of the office note dated 3/9/2025, it appears that what happened to 2?
2 serve lordship flag A. The first report is about
It appears that the notice issued to respondent number 2 has been duly served. It also appears that the notice could not be served on respondent number 3. However, what is the challenge here?
lordship on policy.
First the quantum and then the driving license.
Driving license also.
Who is 3?
Driver.
Right. But
Oh.
he didn't contest in the MSc case.
However, considering the fact that before the tribunal also, the respondent number 3 did not contest the case, the service of notice on respondent number 3 in this appeal is waived. It also appears that in the connected IA number, what is the IA number? 2866/2020 by the order passed on by an order passed today, that is 4th of May 2025, this appeal was directed to be finally listed. This appeal is directed to be listed for hearing for final disposal on 11th of May.
Take only one thing, TCR, I do not see the TCR. It is from Kamrup, Lordship, within 1 week they can bring it. It is from Kamrup to MSAT.
Let the matter be listed for final hearing on 11th of June. In the meanwhile, the registry shall take steps for requisitioning the records of MAC case number
1493 of
1493/2018 from the Motor Accident Claims Tribunal number 2, Kamrup Metro, so that same reaches before this court before the next date of hearing. List accordingly.
Highly obliged.
Item 36.
As per the note by law, the service is not provided. Though the PCR has been received. Ultimate time for the track report of the.
How many respondents are there? Okay. Heard Mr. S. Heard Mr. S.P. Das, learned counsel for the appellant. On perusal of the office note dated 29/4/2026, it appears that the service report in respect of the notices issued to the sole respondent has not yet been received. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent by speed post, before this court on the next date fixed. Let this matter be listed on 11th of May.
Item 37.
Dated 29/4/26 was AD card inspector was 23 evicted. So something like confinement may kindly be.
You are for?
For respondent one, Lordship.
Heard Mr. A.R. Agarwal. Learned.
There is no order for usual service.
Learned counsel for the appellant.
It only written there.
Also heard Mr.
A Kakoti, Lordship.
A.
Kakoti.
A. Thakur.
A Kakoti, Lordship.
Sorry. A. Kakoti. Learned counsel for respondent number 1. On perusal of the office note, it appears that the service report in respect of notice issued to respondent number 2 and 3 is still awaited. Stop. The registry is directed to place the postal track consignment reports of the notices issued to the respondent number 2 and 3 by speed post before this court on the next date fixed. Let this matter be listed on 13th of May.
Of this court notice, the notice was directed to send this usual process. The notice is lying itself in the record. Now we will. So that is to be resent to the proper court lordship.
No, why it is lying in the records?
It was returned, sent wrongly to the different court. And office court order lordship 303/26 lordship. Vice pair number 5 lordship, it was directed to send the in the proper court lordship. But that is not complied with.
Registry shall. It appears that the registry has not complied with the directions given by this court in para number 5 of the order dated 30/3/2026. Stop. It shall comply with the same and put a note to that effect in the office note on the next date fixed. List accordingly.
Item 48.
Praying for a site accommodation, we argue 1,000 even length. In code number 5, can it be passable for the time?
No, what is the, why it is come up for?
TCR has not been received. And Lordship, I have appeared for respondent number 3, Lordship. We have filed our affidavit today, Lordship.
No, why it has come up in orders column? Appearance is complete.
Yes, Your Lordship. Appearance is
The appeal is admitted or not?
yes, or very order was
Mr. Hussain, you are appearing for? Yes.
but go ahead.
You are appearing for? Who is appearing for one?
No, I'm only for I filed. So that's two days. So I will pass it back to. The BJP doesn't do it. Rules and regulations.
I could not file the affidavit to say, because 1 week time may be allowed, I will file affidavit. And we are this one number 2, money. And if you want.
President Baba.
Who is for AM Constructions? Mr. Hussain, you are the proprietor of.
I have no information, my lord, because that's husband number 2 approached me personally. So I appeared on his behalf and Ukalata file. No any documents also submitted by the party to. So I have no brief, my lord, regarding this respondent number 1, my lord.
Heard Miss, what is the name? No, but what is your name? Heard Miss M. Devi, appearing on behalf of Mr. P.R. Sharma, learned counsel for the appellant, who submits that, who prays for a little accommodation as the engaged counsel for the appellant is on legs in a different court. Also heard Mr. B. Hussain, who submits that he has been engaged to represent respondent number 2 only, and he has filed his wakalatnama in this regard. Also heard Mr. U. Saikia, the learned counsel for respondent number 3. Status quo was granted last. Mr. Hussain, learned counsel for respondent number 2, prays for some time for filing written objection in this appeal. The prayer is allowed. Let this matter be listed again on 1st of June. The interim order granted earlier shall continue till next date.
Item 39.
As per office note dated 30/4/26, service on respondent number 456 are complete. The service is complete. The case can be heard, but here also I do not find the ECR Lordship. And this is from Kanguru only.
Heard Miss Adi Majumdar, learned counsel for the appellant. Also heard Miss P. Datta. Who is P. Datta? What is appearing for?
Came in responding 1 2.
Heard Miss N. Das appearing for respondent number 1, 2, and 3. Also heard Miss L. Sharma appearing for respondent number 6. On perusal of the office note dated 30/4/2026, it appears that the postal track consignment report of notices issued to respondent number 4 and 5 indicates that the notices were delivered to the addressees, hence, the notices issued to aforementioned respondents are held to be duly served. The service of notice on all respondents is therefore complete. However, it appears that the records of the connected MAC case has not yet arrived. The registry is directed to issue reminder for requisitioning MAC case number 1197/2022 from the Motor Accident Claims Tribunal number 1, Kamrup. Let this matter be listed again.
Lordship, it can be also listed for hearing, Lordship.
No, it will create problem.
No, like the other case.
Let the other case, the appellant was desperate, but you are not so desperate. Let the record come. Let this matter be listed on 1st of June.
As per office dated 29/4. Service is awaited and LCR also not received.
But Mr. A. Bhattacharya, learned counsel for the appellant. How many respondents are there?
Four.
On perusal of the office note dated 29/4/2026, it appears that the notices issued to respondent number 1 to 4 are not yet served. Stop. The registry is directed to place the postal track consignment reports of notices issued to the respondent number 1 to 4 before this court on the next date fixed. The registry is also directed to issue reminder for the records of MAC case number 7 of 2022 from the Motor Accident Claims Tribunal, Gauhati. Let this matter be listed again on 15th of May.
41.
My lord, I am appearing on behalf of respondent number 1, my lord, Bonti De, my lord. Today we have filed the Kumar.
Okay. Heard
lord,
Miss P.
My lord,
Suti.
submission, my lord, already appeal was admitted, my lord, in the appeal memorandum on dated, my lord, 24/3/2026, my lord. Now pending is the IA. They have filed IA for staying the operation, my lord. My lord, I humble pressure, my lord. I may be disposed of on direction may be given to 50% of amount may be deposit to the rest of bond board.
Yes. What is your submission? Yes, Miss Sutia. 50%. You deposit 50%, we'll dispose the IA.
Yes, ma'am.
Okay. In main case, heard Miss P. Sutia, learned counsel for the appellant. Also heard Mr.
F.A. Hassan.
F. A. Hassan, appearing for respondent number 1/claimant. On perusal of the office note dated on perusal of the office note dated. In main case, just a minute. In perusal of office note dated. 29/4/2026. It appears that the notice issued to other respondents are still awaited. The service report issued in respect of notice issued to other respondents are still awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 and 3 before this court on the next date fixed. Let this matter be listed on. Yes, next date, Putul. 15th of May. We'll consider your IA on 15th of May. She's not ready. We'll consider your IA on 15th of May.
Matter already admitted.
On 15th of May, you argue your case. Let her come prepared. You come prepared on next day.
Obvious rule.
42.
My lord, I have just received the copy, my lord, and I have to collect instruction from the company, my lord. So this matter may be taken another day. My lord. And my name is not shown in.
What is this condonation?
No, my lord.
Clarification of the order, not order dated.
What clarification?
Lordship, actually, there was a mutual settlement amongst the parties, Lordship, that if I withdraw my appeal, then they will make compensation of the awarded amount. I had paid for enhancement of the award. I had filed the appeal, which is pending. And I had made there was an oral.
Both
Yes,
were withdrawal, my lord.
on mutual consent, both the appeals were withdrawn. Now they are not giving me the awarded amount, Lordship.
No, appeals are not pending now.
No, my lord. It is all wrong.
So what clarification you want?
But actually, I should get the awarded amount, Lordship, which I am deprived of.
You will otherwise also get if the appeal is withdrawn.
Lordship.
Yes, my lord.
Now they are not giving me the amount.
Why?
My lord, I have to collect the instruction, my lord.
You file the execution case if they are not giving. You get the instruction. You cannot
1 week time may be given.
disown
Yes, ma'am.
the settlement arrived at mutually between the parties. Heard, Miss? Oh, this was oral.
Yes, my lord.
No, otherwise
So
also.
to collect now, my lord.
But your appeal is not there now. It is disposed of.
Yes.
Her appeal is not there.
Yes, ma'am.
What is there is the award.
Award.
You have to pay
The
the
award.
awarded amount. Heard, Miss M. Devi, learned counsel for the applicant. Also heard Miss L. Devi.
L. Sharma.
L. Sharma, learned counsel for the respondent insurance company. It is submitted at bar that the MSC appeal. Which one is your appeal?
MSC Bill 227 and of 2010 and
Which one was filed by the appellant?
One.
310. MSC appeal 310 of 2010 filed by the present applicant / claimant, as well as the MSC appeal number 227 / 2010 filed by the insurance company were disposed of on being withdrawn by the appellants on arriving at a mutual settlement that on the withdrawal of the appeals, the insurance company shall pay the awarded amount to the claimants. However, learned counsel for the applicant submits that the insurance company is yet to honor the said commitment. On this, learned counsel for the insurance company prays for some time to seek instruction in this regard from the insurance company. The prayer is allowed. How much time?
At least 15 days, my lord.
The prayer is allowed. Let this matter be listed.
It
29th,
may be shown, my lord.
29th May.
Cause list.
Name of Miss L. Sharma may be shown in the cause list as counsel for the opposite party in this case.
Oblige me.
Item 43.
Yes. Besides, for withdrawal of the, you have any objection?
If I have no objection.
Heard, Miss, what is your name? G.H. Give your name. Learned counsel for the applicant. Also, Miss P. Bhattakur, learned counsel for the
Respondent number 1, Your Lordship.
respondent number 1, and Mr. P. R. Busho appearing for respondent number 3. 3 insurance company. This interlocutory application has been filed by the applicant in connection with what has happened to MSC appeal. It is pending
Your Lordship.
in connection with MSC appeal number 473/2025, praying for a direction for allowing the present applicant to withdraw the 50% of the awarded amount deposited before the registry by the, who has deposited?
Lordship, National Insurance Company Limited.
Deposited by the National Insurance Company Limited in pursuant to the order dated 17/10/2025, passed in IA number 3331/2025. Stop. The learned counsel for the National Insurance Company Limited, within bracket respondent number 1, as well as respondent number 3, have no objection if the said prayer is allowed. Hence, the prayer is allowed. The registry is directed to disburse the 50% of the awarded amount which was deposited by the National Insurance Company before it in pursuant to the above mentioned order to the applicant/claimant Sunny Kumar after proper verification. This interlocutory application is accordingly disposed of.
Your Lordship, in the main appeal. Your Lordship, may peruse office note dated 12/3/2026. Respondent number 1 and 3 has filed a wakalatnama, but office note shows that respondent number 2 has already expired, Your Lordship. Respondent number 2 is the owner cum driver, Your Lordship. She is a necessary party, so Your Lordship will maybe given some time to collect the names of legal heirs. Your Lordship.
Miss P. Bhattakur, learned counsel for the appellant. Also Miss, write her name. Appearing for respondent number respondent number 1, as well as Mr. G. Bosho, R. Bosho, appearing for respondent number 2. You are appearing. R. Bosho appearing for respondent number 3. On perusal of the office note dated 12/3/2026, it appears that the process server's report shows that the respondent number 2 has expired on 22/8/2024. Stop. Learned counsel for the appellant submits that since respondent number 2 is a necessary party in this appeal, some time may be granted to the appellant to get instructions and take appropriate steps regarding substitution of the legal heirs of the respondent number 2. The prayer is allowed. Let this matter be listed 12th of June.
Obliged.
Item 44.
My lord, as per office 29 code, services awaited.
Complete.
Awaited.
Heard Mr. A. Bhattacharya, learned counsel for the appellant. Learned counsel for the applicant. On perusal of office note dated 29/4/2026. You have taken steps 29/4/2026. It appears that the service report in respect of notice issued to respondents have not yet been received. Stop. The registry is directed to place the postal track consignment reports of the notices issued to respondent number 1 to 3 by speed post before this court on the next date fixed. Let this matter be listed on 18th of May.
Item 45.
Right. The applicant has filed this IA for allowing them to withdraw the amount deposited by the person.
My lord, one thing is that my last order, lordship, 15/12/25. My lord, little.
Appeal.
I know the
IA.
case point of the appellant has and the appeal along with the IA for the stay of the order.
The lordship has a lordship.
Subject to deposit of 50%.
Already-
And accordingly, they have deposited matter, and I have filed the IA for allowing.
Petrol.
My lord, kindly see this last order. There is some clerical error. It will be Dhubri, the second paragraph, last 1, 2, 3, 4, 5, 6 slide, fifth slide. It will be Dhubri instead of Dibrugarh.
Which order?
15/12/2000. Stay order.
Second paragraph, which line?
Fourth paragraph, second paragraph, fourth line. Tribunal.
It is Dhubri in my order.
It will be Dhubri.
It is Dhubri.
It is Dhubri, not Dibrugarh.
It is not Dibrugarh. Dibrugarh is nowhere mentioned in the order.
One side, in the east side. Dhubri is the west side.
No. In the order sheet, there is no mention about Dibrugarh.
My lord, Dibrugarh is mentioned, my lord.
In your order.
I have got this order. Can you see this, my lord, in IA? In IA, my lord. IA number 4036. It is disposable though. Some mistake made.
Where is 4036?
My lord, I have no objection to for withdrawal of 50%, but subject to furnishing the, because I have challenged the accident also. and also quantum, furnishing the indemnity bond.
Yeah, we are not going to correct that.
Otherwise, registry will cheat.
Okay.
That is the thing. Last time one case also happened. In simple manner.
Okay.
This happening
In
sometimes.
interlocutory application লিখিব 779. 779. This is item number
45.
heard Mr. S. Rahman, learned counsel for the applicant. Also heard Mr. R.C. Paul, learned counsel for the respondent insurance company. This interlocutory application has been filed by the applicant / claimant, praying for allowing the claimant / applicant to withdraw the 50% of the awarded amount which has been deposited by the respondent insurance company before this court in pursuant to the directions of this court given in order dated 15/12/2025 passed in IA civil number 4036/2025. Stop. It is submitted at bar that in the aforesaid order in paragraph number 2 in line number
4. 5.
6, the name of the Motor Accident Claims Tribunal has been wrongly mentioned as Motor Accident Claims Tribunal Dibrugarh in place of Motor Accident Claims Tribunal Dhubri. Same shall be read in the said order. The word Dibrugarh shall be read as Dhubri. Stop. The prayer made by the applicant in this instant interlocutory application is allowed after considering the averments made in the instant application. The registry is directed to disburse the 50% of the awarded amount to the present applicant claimant after proper verification on furnishing of an indemnity bond of the like amount. This interlocutory application is accordingly disposed of. And what will happen in the appeal?
So far appeal piece of I've gone through 25 office note dated 25/3/26. The response number 3 answered, and it is flag A. And 1 is already appeared, and 2 is has not been received. It is awaiting for service. So 3 is driver. So far,
You have taken steps through
both ways.
Through registered post.
Yes.
Speed post also.
Usual process also. At that time, my lord, there was no speed post registered with AD.
So what should we do?
My lord, because response number 3 is the driver and response number 2 is the owner, because we challenge is so waiting for service report of response number 2.
You take steps by registered post.
Against my lord, response number 3, press step.
Yes. Heard Mr. R.C. Paul, learned counsel for the appellant. Also heard Mr. S. Rahman, learned counsel appearing for the respondent number 1.
3. Driver.
You are appearing for respondent number
1.
1 claimant. claimant. It appears that the notice issued to respondent number 2 and 3 have not yet been served.
But in the my lord, the trial court there 2 and 3 was ex parte, although
Still you take
I'll take
one chance.
one chance,
The-
especially my lord, respondent number 3.
The appellant is directed to take fresh steps for issuance of notice on respondent number 2 and 3
Two
by
is
speed.
already my lord, awaiting for service, and is not yet received.
No, you take fresh steps,
Yeah.
2 and 3 by speed post within 7 days from the date of this order, returnable on 8th of June.
Well, it is better for the usual process because usual process, I think, so far I understood.
No, in speed post, we can draw a presumption
Yes, yes, that is the thing.
after
lord,
going through.
I'll
post.
take it further. Much obliged.
46.
8th of July. Heard Mr. A.R. Agarwal issue. This interlocutory application has been filed by the applicant praying for condoning the delay of 300 days in preferring the connected MAC appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of June.
Item 47.
Heard Ms. E. Sharma, learned counsel for the applicant. This interlocutory application has been filed by the applicant for condoning the delay of 386 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 48.
May it please your lordship. My lord, the present IA has been filed for condemnation of delay of 15 days from us.
Heard Mr. D. Rathi, learned counsel for the applicant. This interlocutory application has been filed by the applicant praying for condonation of delay of how many days? 15 days in preferring the connected regular connected MFA, whereby the applicant has impugned the judgment and order dated 26/8/2025 passed by the Railway Claims Tribunal Gauhati branch in OA Roman 3/GHY/150/2013 old. Issue notice to the respondents. You have served notice? No. Issue notice to the respondent. The applicant shall take steps for service of notice on the. You serve notice on the Deputy Solicitor General of India by serving notice on the learned Deputy Solicitor General of India. Let this case be listed again on 10th of June.
Item 49.
May it please your lordship. Your lordship, this matter has come up for the first time. Delay of 70 days in filing the appeal.
Ms. P. Bhattakur, Rennet, counsel for the applicant. This interlocutory application has been filed by the applicant insurance company, praying for condonation of delay of 70 days in filing the connected MAC appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 50.
Same order, 33 days, 10th of June.
Item 51 and 52.
Office note dated 2/5/2026. Notice was issued as usual as linked in distribution.
That mic is not working.
Lordship, as per office note 2/5, the notice has been issued on 2 days before only, on 2/5 only. Notice has gone for the respondent.
5/26.
Notice has been issued to
Respondent number 2.
Respondent to the owner.
no, it has been served or not. Issuance is a different thing.
No, it has not been served. Not been served. I am applying for respondent number 3.
Who is for one?
One, his name has been reflected in the water number.
Heard Mr. A. Hussain.
Appellant.
A. Hussain, learned counsel for the appellant. Also heard Mr. B. Acharya, A. Acharya, learned counsel for respondent number 2. Respondent number 3. Respondent number 3. Though name of Mr. M.S. Alam has been reflected in the cause list as engaged counsel for respondent number 1, none has appeared for respondent number 1 today. On perusal of office note dated, you are appearing for 3.
Yes.
Office note dated 2/5/2026. It appears that the service report of notice issued to respondent number 2 has not yet been received. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 before this court on the next date fixed. Let this matter be listed on 18th of May.
Yes, next on board, but in the matter, they can ask for some member.
Item 54.
I am applying for the claimant.
Your objection?
Claimant, no.
Heard Mr. R. Sharma, S. Sharma, learned counsel for the applicant. Also heard Mr. S. K. Poddar, learned counsel for the claimant / respondent number
1. 2 are the minors.
respondent number 1. You are also appearing for 2 and 3.
They are my sons.
1, 2, and 3 / claimants. This interlocutory application has been filed by the applicant insurance company, praying for condonation of delay of 75 days in preferring the collected MAC appeal, whereby the judgment and award dated 6/9/2024 passed by the Motor Accident Claims Tribunal Morigao in MAC case number 12/29, 12/2019 has been impugned. Stop. Learned counsel for the applicant has submitted that the reasons for belated filing of the appeal beyond the prescribed period of limitation has been stated in paragraph number 3 and 4 of the present instant interlocutory application. Learned counsel for the claimant respondent has submitted that considering the grounds stated in the instant interlocutory application, the claimant's respondent do not have any objection if the delay is condoned. Stop. Considering the grounds stated in the instant interlocutory application to be sufficient cause which prevented the present applicant in approaching the court within prescribed period of limitation in filing the connected MAC appeal. The delay of 75 days in preferring the connected appeal is hereby condoned and the present interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same in admission column after a week on a date to be fixed by registry.
Office note dated 8/4/29/4/26, the respondent, as regards to respondent of 5, no AD card or answer notice of.
Since एक line वो ऊपर लगा देना. Since the claimant respondent has not opposed to the prayer for condonation of delay made by the present applicant, the notice to other respondents is hereby waived.
Possible date may be fixed for appeal.
Date
Otherwise it will not come again. After a week or 10 days.
12 June. Please this matter on 12 June.
Item number 55.
There is a delay of 12 days.
Lord Miss P. Hajorika. Learned P. Hajorika. D. Hajorika. Learned counsel for the applicant. This interlocutory application has been filed under Section 5 of the Limitation Act by the applicant insurance company, praying for condonation of delay of 12 days in preferring the connected MAC appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of June.
Item 53.
What is the matter?
Hello, we have filed the review petition against the order that is passed by our High Court on 7/4/2025. If you the nature of the order, Lordship may kindly see page 29. We have purchased, we had executed an agreement to purchase 2 acres of land. That was done in 2015. And the order has said, nature of the order, Lordship may kindly see, nature of the order, page 30 may kindly be shown, 30.
নিশ্চিত হলো বন্ধ করো। Yes.
Page 30, Lordship, may kindly say, it is from 29. 29, para 44. In view of the ratio of the judgment of Honorable Supreme Court, in the case of Fateh Chand versus Bal Kishan, the CIS 1963 SC 1405, it is said that plaintiff respondent is entitled to refund rupees 4,50,000, which we have paid. For 50,000 only from the defendant appellant. Accordingly, the suit will stand decreed for the monetary amount of rupees 4,50,000 only in favor of plaintiff respondent and against the defendant appellant. In view of the aforesaid discussion, the result of the plaintiff seeking specific performance as against defendant is dismissed and appeal is allowed. However, in favor of the plaintiff, a money decree is passed for a sum of rupees 4,50,000. So I have paid rupees 4,50,000. That has been only given to me, that too after 10 years. And there is no timetable. And this order is, the unlearned judge has referred the case of Fateh Chand in 1963. Thereafter, so many changes are there. So many further judgments are there, which we will
No, what is the error in the judgment?
Error, well, there is no timetable. I am at the mercy of the
When to return?
when he may return it at any time, and that too without any interest. There is no part. So order is, my lord, not clear. I think this order has cost, because on the other hand, in the year 2015.
You were the defendant.
No, I was the plaintiff in the court below. And
You were the plaintiff.
yes,
Now whether
case was decreed in my favor. As is, they shall execute the sell it in favor of the plaintiff.
Okay.
Unless he does this, then that same would be done by the court as per the provision of CBC. Now, our submission is this, that was they filed an appeal. And the appellate court said, what you have paid, that will be given to you, that too without any timetable, without any interest. That too after 10 years. Now, what was the value of the land? Now it is.
No, to invoke review jurisdiction, you have to show error apparent on the face of record.
Error is there, man. Error is there. When there is no timetable. This is a serious error. And on the other hand, my lord, the law, settled law is that if monetary degree is given in such a situation, there should be at least interest. And over and above, the situation which was the value of the land after before 10 years, now it is 20 times more. So, and that was considered by the court below, that is trial court, and now I have been deprived. So I have given the money after selling various deeds, various goods, various properties, only to have a dwelling house. Now, after 10 years, I have been given back the same money, and that too without any definite period. So, my lord, your lordship may kindly be pleased to appreciate that I am in very peculiar situation, that how I have been deprived from the land and also proper money as per present market value. That may be also awarded. That so let the notice go. We will satisfy your lordship on that matter.
Mr. M.U. Mahmood, learned counsel for the review petitioner. This review application has been filed by the petitioners / respondents in RFA number 42/2019, seeking review of the judgment and order dated 7/4/2025 passed by a coordinate bench of this court within bracket Honorable Mrs. Justice Balashi Nandi, since retired, bracket close, in RFA number 42 of 2019. I have gone through the grounds of review stated in the review petition. Issue notice to the respondents. Sole respondent. The appellant shall take steps. The review petitioner shall take steps for issuance of notice upon the respondents, a sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of June.